One of the good things about having an interest in some things and listening to conferences and so forth on social media at convenient times is that sometimes because of what you listen to, you get thrown a lot of things that are similar. So some months ago, I recall a conference for the Financial Investigation Division, which was held in or around February 2023, coming to my attention on YouTube. And there were several speakers at the conference, but the one I recall watching months ago and made a mental note of the presentation is the presentation by Dr. Horace Chang, the Minister of National Security. And it so happens that at that FID conference in February 2023, which is over a year and a half ago, Dr. Chang spoke about the challenges to managing money laundering and the anti-money laundering framework now in place, and he spoke specifically of unexplained wealth orders, the intention of the government to bring those on stream, but noting that there are some constitutional hurdles, and so one literally has to be properly guided before any bill concerning unexplained wealth orders can be brought to the Parliament. Let's hear what Dr. Chang said in February 2023 at the FID conference.
There are still some other measures that we are expecting to come into effect that will help to close some crucial gaps and deficiencies that exist within the system given the nature of our economy. Firstly, the government is eagerly awaiting the outcome of the UK Privy Council judgment in relation to the 2013 amendment to the Proceeds of Crime Act regarding attorneys reporting suspicious transactions by their clients. Secondly, we are looking to further amend the POCO Act to allow for a wider application of the unexplained wealth order as part of the legislative framework dealing with money laundering and other financial crimes. These orders will ensure that competent authorities will be able to apply to require an individual to explain and account for the origins of their assets. This, of course, has to overcome a small hurdle, maybe not so small, in some areas, as a concept the law's advisor referred to as reverse burden proof was in fact removed from our Constitution. Well, not removed, it was just written out. I think a number of laws in the room, but when the Charter of Rights was being written, this was just not returned to the chapter it was in, and it has serious implications in terms of investigating individuals in money laundering. The United Kingdom has it still because the United Kingdom operates on a common law basis and precedents, and it's a very powerful tool. We took this element of right of privacy a little bit far, and it has put some constraint on our capacity to investigate this particular kind of activity. But I have the lawyers reviewing it, and we hope we can find a route to genuinely investigate individuals with significant amount of unexplained wealth, but no known predicate criminal offense. But that's really the benefit of this kind of amendment.
Let's go. So that was Dr. Chang over a year and a half ago at the FID conference, where, as far as I understand him, he's making the point: we do intend to amend the POCO, Proceeds of Crime Act, to bring this unexplained wealth order. But we have more than a small hurdle, because when the Charter of Fundamental Rights was drafted and passed, it did not carry over and include a very crucial matter called reverse burden, where a defendant or a respondent, perhaps in this case, the onus is put on him or her to explain, either to investigator or later to court, the source of the money that he is coming to if his legitimate income cannot explain how he came into that money. And it is not just a small technical issue. It is a very high fundamental issue that touches a myriad of constitutional rights. I note as well that Canada, which has somewhat of a similar constitutional arrangement to us, because if you recall, even in the NIDS case, the court, I believe, mentioned a case from Canada and the test that was applied there to assist in interpreting some provisions in the Jamaican Constitution. So there is some similarity, but it is not a one-on-one similarity between the Canadian and the Jamaican Constitution. And again, I saw some months ago and went back to viewing it again recently, because when the Civil Forfeiture Amendment Act of 2023 was tabled in the British Columbia House, one of the representatives spoke on the amendment and the concerns raised then, and the promise as well to challenge the unexplained wealth order, which was included in the Civil Forfeiture Amendment Act. The promise to challenge when the law is passed because of the concerns that there are serious violations to the presumption of innocence and other constitutional rights of Canadians, which are eroded by this particular amendment. Here's part of what took place in the British Columbia, in the House, concerning this amendment.
And I appreciate the opportunity to stand and speak today to the Civil Forfeiture Amendment Act. These amendments came as a result of the Cullen Commission's investigation and subsequent recommendations to combat money laundering in the province. Proposed amendments make it easier for authorities to seize property they suspect help facilitate illegal activity. It also makes it easier for authorities to bust illegal cannabis operations and to seize financed vehicles. Finally, it creates unexplained wealth orders, which can force organizations with large amounts of unaccounted for wealth to explain themselves to government or face seizure of property. This last point, unexplained wealth orders, would make this the first legislation of its kind in Canada. But unexplained wealth orders only apply to property stored in British Columbia. The Cullen Commission into the money laundering in June 2022 recommended that unexplained wealth orders be implemented in BC to, quote, remove the profit incentive for organized crime. Unexplained wealth orders do not require a clear link to crime, unlike criminal forfeiture, which typically comes after a conviction, and a civil and administrative forfeiture, which do not require criminal charges or a conviction. I think it's important to note that there are some concerns with unexplained wealth orders that have been recorded. BC Civil Liberties Association has been very clear that they're staunchly against these changes, saying that, quote, they're an unnecessary expansion of government power and an unacceptable infringement of Canadians' rights to the presumption of innocence and due process and privacy, end quote. The Director of Litigation for the BC CLA said that the legislation would, quote, create a situation where British Columbians were going to have to go to court to prove they are not criminals, and that's unconstitutional, end quote. These are serious concerns that are raised by the BC Civil Liberties Association, and if these amendments are passed, there are concerns that they will, but they're raising the concerns that they will violate the Canadian Charter of Rights and Freedoms and the presumption of innocence, which is a fundamental pillar of our judicial system. It will be interesting to hear from the Minister, and I know that the Premier has said that he has no doubt, in quotes, that this legislation will be challenged in court, but that he believes, quote, that he'll be successful and that we need to address these issues for British Columbians, end quote. a point the last point there, which I absolutely agree with. So it'll be interesting to see the discussion that unfolds here at the committee stage and how the government is balancing, of course, the recognition that there has been an extreme amount of wealth that's been generated from illegal activity, lots of expensive vehicles and houses and other items purchased, and in that glorification of crime, the fast cars and the big houses. And so there is a balance, absolutely, that needs to be struck here, and it'll be interesting to hear the discussion.
Yes. So that is part of the discussion that took place in Canada with I believe this was a second reading of what is now the Civil Forfeiture Amendment Act of 2023. And we must have an interest in watching the developments there, just to see exactly whether challenges are brought, and if so, how do those challenges fare in light of the British Columbia Civil Liberties Association raising concerns about the breaches under the Constitution in Canada. From my understanding as well, Trinidad and Tobago has passed an Unexplained Wealth Act and has further amended another act. And since that time, I believe it took place in 2019, and there has been one use of the Unexplained Wealth Order, where a preliminary Unexplained Wealth Order was granted to the police in Trinidad against named individuals. The persons challenged the use of the preliminary Unexplained Wealth Order, and the court set aside the order which was granted to the police in Trinidad and Tobago. And as a result of that, the police appealed to the Court of Appeal, which reinstated the Unexplained Wealth Order, and that matter is now headed to the Privy Council because there are so many issues that have to be crystallized in this particular appeal. So I look forward to seeing what is going on, particularly in countries where the constitutional arrangements are somewhat similar to Jamaica. So here we are now with a number of groups calling for the Andrew Holness-led administration to put renewed focus on bringing the amendment to the Proceeds of Crime Act, even though the Minister of National Security has said to us there is further legal research being done to ascertain that if and when a bill is drafted, that the bill does pass the smell test of constitutionality. People seem to have brought things together as if the attempt now by Dr. Chang to say to the country, we are not now putting it on the front burner because further research is being done, that it is coinciding with the issue concerning the Prime Minister's challenge to the Integrity Commission and how the Integrity Commission operates in the last report it sent to Parliament. And these things happen to be just mere coincidences in my view, because as I said to you, in February 2023, a year and a half ago when the minister spoke at the FID conference, the minister told us then about this more than small hurdle that they have to overcome because of the constitutional arrangements now in place with the Charter. Is it appropriate? Is it ethical even for any government to, in the face of public clamoring, to bring any bill to Parliament if it knows that the bill does not on the first blush pass the constitutional test? Is it ethical for them to do that? Or should we await further research? Or should they table the bill and allow for joint select committee where other views can come and suggest to them the ways in which the bill can be made constitutional? I think this is part of the discussion that we need to have, but the way in which I think we've brought everything together is not necessarily the way in which the things have unfolded over time. So what was recently disclosed by the newspaper, as I said, it's not new information. It's information that's over a year and a half old because of this public conference that took place with the Financial Investigation Division. So the other question we have to ask is whether, in the absence of this unexplained wealth order at the moment, are there any other provisions now operating that can assist within the context of the anti-money laundering framework that is now existing? And I believe that there are. There are quite a few provisions which perhaps we should set up a session to talk with some of the people, the experts in proceeds of crime and asset forfeiture and all of those things. Unjust enrichment as well remains something that is available, if not in statute, then certainly to common law. They're all out there. So it's not as if we're left uncovered. Yeah? But what needs to happen, all of these government ministries and their legislative drafters, the Attorney General's chambers, which has the responsibility for doing the research on some of these matters, we know for a long time now that they need more people. Because there's no way the minister should have said this in 2023, and a year and a half later, the research is not even complete on where we are and what can be tabled. And that is happening because we have skeletal staff in a lot of these departments, in the AG's chambers, with the volume of matters it has to contend with. They don't get around to doing things as quickly as they should. But what has come to me is not new information. It's always out there. So when it is pitched to me as new, no, I was shocked to find that a lot of people didn't hear that this was said at the FID. Even when he made the presentation in the Parliament, the promise that he's made, I didn't read the promise without reference to what he said at the FID conference. Perhaps we need to go back to finding out what happened in the move from Chapter 3 of the Constitution to the Charter, and how is it that the reverse burden, as he said, was written out of the Charter. So we continue to watch and look forward to more on this and other matters. Those are my thoughts for the moment.